d. Until the record in a case shall have been filed in a court, as hereinafter provided, the board may at any time, upon reasonable notice, and in such manner as it shall deem proper, modify, or set aside, in whole, or in part, any finding or order made or issued by it. The board shall have power to petition any court of appeals of the United States, or if all the courts of appeals to which application may be made are in vacation, any district court of the United States, within any circuit or district, respectively, wherein the unfair labor practice in question occurred, or wherein such person resides or transacts business, for the enforcement of such order, and for appropriate temporary relief or restraining order, and shall file in the court the record in the proceeding, as provided in Section 2112 of Title 28, United States Code. Upon the filing of such petition, the court shall cause notice thereof to be served upon such person, and thereupon shall have jurisdiction of the proceeding, and of the question determined therein, and shall have power to grant such temporary relief or restraining order as it deems just and proper, and to make and enter a decree enforcing, modifying, and enforcing as so modified, or setting aside in whole, or in part the order of the board. No objection that has not been urged before the board, its member, agent, or agency, shall be considered by the court, unless the failure or neglect to urge such objection shall be excused because of extraordinary circumstances. The findings of the board with respect to questions of fact, if supported by substantial evidence on the record considered as a whole, shall be conclusive. If either party shall apply to the court for leave to adduce additional evidence, and shall show to the satisfaction of the court that such additional evidence is material, and that there were reasonable grounds for the failure to adduce such evidence in the hearing before the board, its member, agent, or agency, the court may order such additional evidence to be taken before the board, its member, agent, or agency, and to be made a part of the record. The board may modify its findings as to the facts, or make new findings by reason of additional evidence so taken and filed, and it shall file such modified or new findings, which findings with respect to question of fact, if supported by substantial evidence on the record considered as a whole, shall be conclusive, and shall file its recommendations, if any, for the modification or setting aside of its original order. Upon the filing of the record with it, the jurisdiction of the court shall be exclusive, and its judgment and decree shall be final, except that the same shall be subject to review by the appropriate United States Court of Appeals, if application was made to the District Court, as herein above provided, and by the Supreme Court of the United States upon writ of certiorari or certification, as provided in Section 1254 of Title 28. F. Any person aggrieved by a final order of the board granting or denying in whole or in part the relief sought may obtain a review of such order in a United States Court of Appeals in the circuit wherein the unfair labor practice in question was alleged to have been engaged in, or wherein such person resides or transacts business, or in the United States Court of Appeals for the District of Columbia, by filing in such court a written petition praying that the order of the board be modified or set aside. A copy of such petition shall be forthwith transmitted by the clerk of the court to the board, and thereupon the aggrieved parties shall file in the court the record in the proceeding, certified by the board, as provided in Section 2112 of Title 28, United States Code. Upon the filing of such petition, the court shall proceed in the same manner as in the case of an application by the board under subsection E of this section, and shall have the same jurisdiction to grant to the board such temporary relief or restraining order as it deems just and proper, and in like manner to make and enter a decree enforcing, modifying, and enforcing as so modified, or setting aside in whole or in part the order of the board. The findings of the board with respect to questions of fact, if supported by substantial evidence on the record considered as a whole, shall in like manner be conclusive. G. The commencement of proceedings under subsection E or F of this section shall not, unless specifically ordered by the court, operate as a stay of the board's order. H. When granting appropriate temporary relief or a restraining order, or making and entering a decree enforcing, modifying and enforcing as so modified, or setting aside in whole or in part an order of the board as provided in this section. The jurisdiction of courts sitting in equity shall not be limited by sections 101 to 115 of Title 29, United States Code. I. Repealed. J. The board shall have power, upon issuance of a complaint, as provided in subsection B, charging that any person has engaged in, or is engaging in an unfair labor practice, to petition any United States District Court, within any district, wherein the unfair labor practice in question is alleged to have occurred, or wherein such person resides or transacts business, for appropriate temporary relief, or restraining order. Upon the filing of any such petition, the court shall cause notice thereof to be served upon such person, and thereupon shall have jurisdiction to grant to the board such temporary relief, or restraining order, as it deems just and proper. K. Whenever it is charged that any person has engaged in an unfair labor practice, within the meaning of paragraph 4d of Section 8b, the board is empowered and directed to hear and determine the dispute out of which such unfair labor practice shall have arisen, unless, within 10 days after notice that such charge has been filed, the parties to such dispute submit to the board satisfactory evidence that they have adjusted or agreed upon methods for the voluntary adjustment of the dispute. Upon compliance by the parties to the dispute with the decision of the board, or upon such voluntary adjustment of the dispute, such charge shall be dismissed. L. Whenever it is charged that any person has engaged in an unfair labor practice, within the meaning of paragraph 4a, b, or c of Section 8b, or Section 8e, or Section 8b, 7. The preliminary investigation of such charge shall be made forthwith and given priority over all other cases except cases of like character in the office where it is filed, or to which it is referred. If, after such investigation, the officer or regional attorney to whom the matter may be referred has reasonable cause to believe such charge is true and that a complaint should issue, he shall, on behalf of the board, petition any United States District Court, within any district where the unfair labor practice in question has occurred, is alleged to have occurred, or wherein such person resides or transacts business, for appropriate injunctive relief pending the final adjudication of the board with respect to such matter. Upon the filing of any such petition, the district court shall have jurisdiction to grant such injunctive relief or temporary restraining order as it deems just and proper, notwithstanding any other provision of law, provided further that no temporary restraining order shall be issued without notice, unless a petition alleges that substantial and irreparable injury to the charging party will be unavoidable, and such temporary restraining order shall be effective for no longer than 5 days, and will become void at the expiration of such period, provided further that such officer or regional attorney shall not apply for any restraining order under Section 8b. 7. If a charge against the employer under Section 8a(2) has been filed, and after the preliminary investigation, he has reasonable cause to believe that such charge is true and that a complaint should issue. Upon filing of any such petition, the court shall cause notice thereof to be served upon any person involved in the charge, and such person, including the charging party, shall be given an opportunity to appear by counsel and present any relevant testimony, provided further that, for the purposes of this subsection, district court shall be deemed to have jurisdiction of a labor organization, 1. in the district in which such organization maintains its principal office, or 2. in any district in which its duly authorized officers or agents are engaged in promoting or protecting the interests of employee members. The service of legal process upon such officer or agent shall constitute service upon the labor organization and make such organization a party to the suit. In situations where such relief is appropriate, the procedure specified herein shall apply to charges with respect to Section 8b. 4d